Imbert and Armour should resign. Thursday's ruling by the Privy Council allowing embattled Auditor General Jaiwandi Ramdas to pursue a case over a cabinet-appointed probe into the handling of a misrepresentation of revenue in the national accounts is both an embarrassment and a condemnation for the state. This was the opinion of senior counsel Israel Khan, who yesterday called on Finance Minister Colm Imbert to tender his resignation over the debacle, which he said continued to be a waste of taxpayers' dollars. Weighing in on the ongoing matter yesterday, Khan told Guardian Media, "I think he should tender his resignation." Confirming it was Imbert he was in fact pinpointing, Khan emphatically replied, "Yes. Yes. The Minister of Finance and the AG also." He went on to clarify that the role of the AG was to save taxpayers' money and advise the government in relation to litigation, and this is an obviously wrong application that they were making that the Privy Council criticized them severely. Khan said this meant the AG has received a criticism also. He said if it was confirmed that Reginald Armour had advised the state to pursue this matter, then he too should resign. The senior attorney pointed out that it would be interesting to know how much the state's attorneys had been paid in this matter. Khan added that the Privy Council does not go out of their way to criticize people like that, and its quasi-political statement, "Why is the Minister of Finance not being investigated?" is a condemnation of this government and the Attorney General. Privy Council's ruling an important decision, Lala. Describing the Privy Council's ruling as an important decision, Attorney Om Lala yesterday said, "It goes towards enforcing the independence of the Office of the Auditor General." Reflecting on the circumstances of the matter, Lala said, "The law provides for the Auditor General to be an independent officer, and the Constitution provides that there ought to be no interference." He said in Ramdas's matter, the perceived interference by the Minister of Finance raised grave concern. Addressing the public vilification of Ramdas thus far, he emphasized that this was not a final decision, but rather a preliminary ruling that allows her to move forward with her judicial review action. He underscored that it sends a very important signal that she should be allowed to have her case heard, and that the state has no merit cause they lost to the Court of Appeal and the Privy Council. Lala said independent offices needed to remain as such, and that any interference should be aggressively challenged. In this case, he said the country should have welcomed the thorough audit by Ramdas as to the financial discrepancies uncovered, instead of chastising and vilifying her. Lala said it was disappointing that the state had chosen to invest time and money to go all the way to the Privy Council to prove a point which the Court of Appeal had been very clear about. 5 law lords of the Privy Council dismissed the appeal brought by Imbert and the Cabinet after hearing submissions from attorneys for the state at the United Kingdom Supreme Court building in London, England, on Thursday. In the appeal, attorneys for Imbert and the Cabinet contended that the Court of Appeal got it wrong when it overturned the decision of High Court Judge Westman James to refuse Ramdas leave to pursue her case over the constitutionality of the probe. In June, Justice James ruled that Section 116(6) of the Constitution, which insulates the Auditor General from being under the direction and control of any other power or authority, could not apply to investigations, such as the one ordered by the Cabinet. He also stated that Ramdas failed to prove bias by Imbert. Weeks later, Justice Peter Rajkumar delivered the appeal court's review of Justice James' decision that the threshold for granting leave in such a case was low, before he and his colleagues remitted the case to be considered by another High Court judge. Marvin Gonzalez, who is acting as AG in the absence of Armour, who is abroad, said, "I don't think it will be appropriate for me to comment. The substantive AG may comment, if he so chooses." The dispute between Ramdas and the ministry. The dispute between Ramdas and the ministry arose in April after the ministry sought to deliver amended public accounts, which reportedly explained a $2.6 billion underestimation in revenue. Ramdas initially refused receipt as she claimed that she needed legal advice on whether she could accept them after the January statutory deadline for submission. Ramdas eventually accepted the records and dispatched audit staff to verify them. She then submitted her original annual report to Parliament, which was based on the original records. In subsequent legal correspondence between the parties, Ramdas claimed that her audit team was unable to reconcile the amended records based on documents it audited. She also contended that the amended records appeared to be backdated to the original statutory deadline in January. Ramdas also took issue with the fact that the discrepancy was initially estimated at $3.4 billion. Imbert repeatedly denied any wrongdoing, while his lawyers claimed that the reconciliation after the initial estimate revealed that the variance was in fact $2,599,278,188.72, which was attributed to value-added tax, VAT, individual, business levy, and green fund levy contributions. They also claimed that checks in relation to the approximate $780 million difference between the initial and final estimated variances were attributed to tax refund checks to taxpayers issued for the 2022 financial year, being cashed in the financial year 2023. They attributed the error to a switch from a manual to an electronic check clearing system by the central bank. They claimed that there was no backdating, as they noted that the allegation was made because a document related to the original public accounts was inadvertently included in the revised documents. They also contended that Ramdas acted illegally in initially refusing to accept the amended accounts. Imbert eventually agreed to lay the original report in Parliament and did so on May 24. His decision was based on the understanding that Ramdas would issue a special report clarifying her initial report based on the amended records provided. The report was eventually supplied, but Ramdas maintained the similar concerns that were raised in her initial report. In laying the special report in Parliament, Imbert opposed comments made by Ramdas in an affidavit that her ability to perform a proper audit and verify the issues that caused the error was hampered as she was allegedly blocked by the central bank from accessing its electronic check clearing system.